I'll begin with introductions. Our moderator is going to be Michael Kerr-Nicolas, who's the Executive Director of the UCLA Institute for Technology, Law, and Policy, and also an affiliated fellow with the Information Society Project at Yale Law School. Michael has 10 years of experience in civil society, working on projects connected to freedom of expression, transparency, and digital rights. So he'll be leading this panel on thinking big about FOIA reform, and our panelists will include Margaret, who you just heard from, the Lawrence Herman Professor in Law at the Ohio State University Moritz College of Law. And we also have Adam Marshall, Senior Staff Attorney at the Reporters Committee for Freedom of the Press. His work includes federal and state public records litigation, writing amicus briefs, and training journalists. We have Toby Mendel, the Executive Director and founder of the Center for Law and Democracy, a Canadian-based international human rights NGO that provides legal and capacity-building expertise regarding foundational rights for democracy. And then we have Colleen Murphy, the Executive Director and General Counsel of the Connecticut Freedom of Information Commission. She's held that position since 2005. She's also a frequent speaker and consultant on government transparency, information policy, electronic information issues, privacy, data protection, and the First Amendment. So we have an all-star panel to lead us off, and I'll pass it off to Michael. Before I just want to note that we will have a Q&A period at the end of the discussion. And to ask your questions, please put them in the Q&A chat box at the bottom of your screen, and then we'll ask them when the panelists are done with their discussion. All right, Michael, off to you.
Hi, thank you so much for that introduction, and thanks to Yale ISP and Mafia for allowing us this opportunity and for hosting this incredible conversation. You know, I think that Margaret's keynote provides an excellent framing not only of the challenge, but also of proposed solutions. And I don't think anyone is of the solution that these kinds of changes are going to be easy, either politically or structurally. But the foundational importance of transparency and oversight to democratic accountability, which I think can be directly tied back to broader democratic challenges that this country is experiencing, necessitate bold steps to repair this system. And so the purpose of this panel is to explore new and better oversight models. And I would like to start by giving each of you a chance to respond to what you just heard and to offer your thoughts on the potential of the oversight solution that Margaret has raised. Maybe beginning with Adam and then going to Toby and then to Colleen after that.
Sure thing. Well, Professor Koka, as usual, is right that big changes are needed. I wanted to talk a little bit about the fundamentals of what it would look like to try to push change through. As Professor Koka said, there have been FOIA reforms more or less every 10 years over the last few decades. Each of those has been a pretty Herculean effort, though. FOIA is wonderful in that it is truly a bipartisan issue. Both Republicans and Democrats, often line up behind FOIA reform. There are great FOIA champions in the Senate on both sides of the aisle, and it is really a true bipartisan issue, and that's wonderful. The flip side is that because of the other challenges in passing legislation these days, given the kind of hyper-partisan nature of things, FOIA reform almost always has to be passed through the consent calendar, meaning that you have to get the entire Senate more or less on board. And that can be challenging sometimes. In the run-up to the latest round of FOIA reforms in 2016, you saw several failed attempts in the months and years before that were held up in some instances by a single senator or a couple senators. So I think any type of large structural reform is going to have to do a lot of work at the outset to line up everyone and make sure that everyone is on board. And I think that the research that Professor Kolka has done and that many other people are doing is going to be really critical in providing the theoretical and factual basis for the need for reform. The other thing that I think fundamental FOIA reform faces as a challenge is resistance from within the executive branch. Professor Kolka noted this a little bit in terms of OGIS, and we've seen that pretty consistently in that there's resistance within the executive branch to improving OGIS. The Reporters Committee, where I work, is in the middle of a FOIA lawsuit about a bill that was called the OGIS Empowerment Act, which was tried to be passed in 2018, but did not prevail. And our FOIA request sought records from within the Department of Justice about this reform. It was a pretty simple bill. It would have said OGIS, in carrying out its functions, can look at the government records in question. That's all it said. It was a very, very straightforward bill that would have really improved everything. And this bill set off a 5-alarm fire within DOJ. And you saw numerous components of DOJ, including the Office of Information Policy, mounting an effort to oppose this very simple bill. That was during the last administration, but before that, you saw during the Obama administration, again, significant opposition to FOIA reform from within the executive branch. And so I think for this type of broad reforms that we're talking about today, there's going to have to be a strategy about how to deal not only with Congress, but from resistance within the executive branch itself. So lots of other things to say, but I will turn it over to my co-panelists.
Thank you so much, and it would be great to hear from Toby next on the particularly as Toby, I know that you've seen a lot of these systems, worked with a lot of these different oversight structures, in many cases supported in the creation of many of these structures. Can you maybe start with just a general framing of the importance of independent administrative bodies in a robust system and the potential role that they could play in supporting implementation?
Sure, thanks, Michael. I'm going to focus in my comments entirely on the second point that Margaret raised, that's to say the independent oversight bodies. And as you already implied, my comments are based really on 25 years of working in numerous countries around the world, upwards of 60. I never actually counted them, and I have worked a lot with governments to draft legislation and with oversight bodies themselves. So quite a lot of experience on that. And I'm just going to drop into the chat some links to our RTI. We like to call this right the right to information, not freedom of information. It is a human right under international law. And I'm just dropping into the chat. Let me try to drop into the chat. I'll do that later. Drop in the chat some links to the RTI rating pages that are most relevant. The RTI rating is a fairly sophisticated methodology for assessing the strength just of the legal framework for the right to information and freedom of information. So it doesn't look at implementation. And it has 61 separate indicators, each of which corresponds to a positive feature of a right to information system. And they're divided into 7 different categories. And there's a whole category just focusing on appeals, almost all of which looks at the features of the independent oversight body. And as Margaret mentioned, there are dozens and dozens of countries around the world that have dedicated independent oversight bodies for FOIA. And those range from the sort of more peer group countries to the US, like Canada and the UK, to much poorer emerging democracies like Sierra Leone, Sri Lanka, Indonesia. So while this may seem like quite a significant change in the US context, It is absolutely not a controversial way of doing a FOIA as established around the world. And I think that the main point of this really, and I think Margaret has touched on that, the main benefits of this is that these bodies give requesters, give applicants an accessible remedy. For the vast majority.
So sorry for that interruption, Toby. I think you want to kick it off again? I'm not sure where you were going.
Where I left off, perhaps. Yeah, so as I was saying, for the vast majority of information seekers, recourse to the courts is simply not a viable option. Yes, they want the information, but not so much that they're going to go through the extremely costly, time-consuming, and also resource-consuming in the human resource sense, the process of litigating through the courts. Really, the driver for FOIA is to enable people to access information held by government, and an independent administrative oversight system allows them to take that out of simply something that operates at the discretion of public bodies and have recourse to an independent decision-making process around it. So that's really the key driver. It also, as Margaret referred to, the administrative bodies reach decisions much more quickly than courts. So it delivers on the reality of access to information, which needs, in many cases, to be reasonably rapid if it's to be effective. And in a lot of countries, these bodies serve two purposes. So they're sort of the adjudicative or dispute resolution side of it, but they also have a strong promotional role. And it's actually very important to have a central expert body that can provide promotional support for the system, whether that's to public authorities or agencies or requesters, or systemically designing, for example, in Mexico, the oversight body designed the central electronic requesting platform, which is a wonderful feature of their system, and that was all done by the oversight body. So they play a number of roles. I want to just touch on a few of the points that Margaret mentioned and elaborate a little bit on that and add a couple of points to that. So firstly, these bodies ultimately are adjudicative in nature. So just like courts, they need to be independent, the same rationale, basically. And there are a lot of different ways of enhancing or protecting the independence of these bodies. This is one of the features of FOIAs that is closely linked to the local legal and administrative and political environment. So there's no one size fits all here, unlike many of the features, for example, the exceptions, basically. You can take them off the shelf and put them down for any country and it'll work, but that's not the case with the oversight body. It's very important for the appointments process to be protected against control by the government. Involving more actors tends to increase the independence of the process. So having civil society, different parts of the legislature, perhaps the government playing a role. The money, the budget also needs to be protected against government control, another key feature of independence. I think it's very important to have requirements of expertise for members in the first place, that rules out nepotistic or inappropriate, or not rules out, but limits those kinds of appointments, and also prohibitions on individuals with strong political connections. In terms of powers, something that Margaret didn't touch on, but it's very, very important for this body to have an appropriate package of powers. And I would divide those into two categories. The first is powers to investigate complaints in the first place, so to find out what their decision should be. And there are three key parts of that power. The first is to be able to compel individuals, witnesses, to appear before and to give testimony. Secondly, to access the information which is being sought whether or not it's claimed to be confidential. In Canada, for example, the Information Commissioner and at least one of her staff have the highest security level rating within the government, signals and intelligence standard security access, so that they can access any document at all within the whole system. And then thirdly, it's very important for these bodies to be able to inspect agencies. Often agencies may say they don't have the information, and the oversight body needs to be able to go there and look around and see if that claim is correct. In terms of remedies, it's also obviously it needs a package of powers. The most obvious one is to order the information to be disclosed. Where the fee that's being charged is too high, it should also be able to order the lowering of that fee or the return perhaps of the fee. Also to order information to be provided in the format sought by the requester where that didn't happen. Margaret talked quite a lot about the problem of delays, which are a huge problem not only in the US, but basically across FOIA systems around the world. You cannot order the timeline to be shortened. By the time the oversight body reaches a decision, the time is already passed for the information. I mean, it was already late, because that was why the appeal was brought, and then the appeal takes its own time. So that can't be directly fixed in the way that other issues can. So I think it's very important for these bodies to be able to order compensation to be paid to requesters, both sort of as a salve to the requester, but also as a sort of a shot across the bows for public agencies. Nothing like making them pay to sort of disincentivize delays. I want to just spend a couple of minutes talking about the issue of binding order-making powers. And as Margaret mentioned, in Canada at the federal level, we transitioned from a recommendations system to a binding order-making powers system in 2019. But we have a variety, every single province in Canada, every single province and territory in Canada, so we have 14 FOIA jurisdictions in Canada, every one of them has an information commissioner, and they're about 50-50 in terms of order-making powers or not. So we have a pretty rich palette of experience on this issue. I think first of all, to dispense with what is often raised as an objection to this, that making the process legally binding bureaucratizes it, formalizes it, and therefore elongates it. The experience in Canada has been precisely the opposite. Where you only have recommendation powers, there's very little incentive for the agency to cooperate with the oversight body in terms of its timelines, in terms of providing information, in terms of coming to meetings, in terms of going through the procedure. And the oversight body can't really force that through without the agency, because they will have lost the agency by doing that, and therefore almost guarantee that the recommendation won't be followed. In a binding system, it's quite different. That you order the agency to provide you something within 2 weeks, and if it doesn't do that, you start using your binding powers, or you move the process along without that, and come to a decision, and the decision will be binding. So you don't have to rely on the friendliness of the agency, if you will. So what we have found is that it does the opposite in that sense. I think that you can justify recommendation powers where a high percentage of those recommendations are complied with. Where they're routinely ignored, then you haven't really done anything by going through an oversight system. At the federal level in Canada 10 years ago, the compliance rate was north of 90%. And at that point, there was quite a big debate about whether order-making powers were necessary. That started to fall down quite a lot subsequently, and by the time the order-making powers came in, it had fallen well below that, and I think that kind of justified the order-making powers. I'll leave it to people who are more familiar with the US system to give a solid opinion on what the compliance rate would be in the US, or what it is perhaps with the OGIS recommendations, but I'm going to guess that it would not be high enough to justify a non-binding powers, non-binding order-making powers. There's a couple of options in terms of the enforceability of these binding orders, and your paper addresses that. I think the best one, from my experience, is registering the decision of the administrative body in a way that makes it equivalent to a court order. We have effective, in rule of law countries, we have very effective systems for enforcing court orders. tethering the oversight body's decision to that system is almost certainly going to be effective. So I think it's a fairly simple mechanism. And finally, just a couple of words on mediation. All of these bodies, whether or not their enabling legislation explicitly refers to it, they all undertake mediation. Mediation is, of course, an extremely effective, where it works, it's an extremely effective way of resolving disputes. And most of these bodies resolve significantly more than 50% of the disputes through mediation. But mediation works best where you have the binding order making stick behind it. So you engage in mediation, the fact that if the mediation fails, you will go to the order making power process, adjudication process. That really motivates the participants in the mediation to collaborate and to try to make that work. You do need clear institutional separation within the oversight body between the mediation wing and the adjudication wing. Obviously, the mediation process can't pollute, as it were, the adjudication process. So I'll stop with those comments, and hopefully we'll have time for some discussion.
Of course, thank you so much for that. And so I think we'll go on to Colleen next. I'll frame it slightly differently, insofar as Connecticut is one of a handful of states that has set up an independent administrative body. My read on it, at least, is that it's probably the strongest model that's been established. So as someone with experience in implementing such a system, I wonder if you could first introduce the model as it exists in Connecticut, and then provide your thoughts on its efficacy.
Sure. Thank you so much for the opportunity to speak today. Really appreciate the opportunity to be here and talk to you about the Commission and engage in this, very thoughtful discussion. And also, I want to thank Professor Cuoco for a wonderful keynote and a terrific paper that she co-authored with you, Michael. Really, I found it to be excellent overview of where we are right now, and I learned a few things, so that was wonderful. I'm Colleen Murphy, the Executive Director and General Counsel of the Connecticut FOI Commission. And from reading the paper and hearing some of the dialogue here today, I think it's clear to me that our commission checks a lot of the boxes highlighted in the article and by the speakers that are necessary for overseeing oversight. Not a perfect model. I have thoughts on the ways our model could be better, but and I had no role in its creation, so I can't take any credit for that. But we at the Commission view ourselves as stewards of this entity that was created a long while ago now, and we really spend a lot of time striving to maintain what we have, which is a challenge. Even once you have a pretty good oversight mechanism, making sure that it is not eaten away at is a big challenge in what we do. And we also look for ways to improve upon it if possible. So I'm sure many of you know about the Commission, but I'll just try to go through what we do and our structure, and again, with a focus on some of the critical points that others have suggested are needed in an oversight regime. So we're an independent oversight agency charged with administering and enforcing Connecticut's FOI Act, which was passed way back in 1975. Like many states, there was a push for reform following Watergate. We had our first female governor, Ella Grasso, elected in her own right in Connecticut at that time, and she had vowed to secure passage of a comprehensive FOI law if elected. And she came through on that promise. And it's pretty remarkable now to think about, but our law passed unanimously. Toby was talking about the need for things to go on consent calendar, in order to get reform. it's hard to imagine there being unanimous passage even in our state today. So that was quite remarkable. And the law created a comprehensive FOI Act, and most important to this discussion, an independent body to hear and resolve access disputes involving both records and meetings. So that too kind of points out our law is pretty broad. Not many entities cover both of those prongs in the open access world, but ours does. But our focus today, I know, is largely on records, but it just shows you again how I think forward our law was, forward thinking. And we have broad jurisdiction everywhere, every entity from the governor, the executive, all executive branch agencies, even the legislature, which is pretty unique, and a segment of the judicial branch as well. So again, broad jurisdiction, and the decisions reached by the commission are binding, right? A key concept and key to this discussion. They're not recommendations, they're not advisory, they don't have to be run by anybody else. The commission makes its own decisions, and they are binding. The structure of the commission resides within the executive branch, which again is, in some regimes that are created, it's challenging to be within the executive branch, but we're an executive branch agency, but we're not part of the executive branch. And that's what I always point out, or any administration. I think this is the single most important key to our structure. It's a 9-member agency with 5 gubernatorial appointees. And you'll see as I'm talking, there were a lot of attempts to make sure that there was independence throughout this process. And it's a 9-member agency, 5 governor appointees who serve staggered terms. So that's really important too, that no one new governor gets to come in and clean house and put in his or her own commissioners. And no more than 5 can be from any one political party. The other representatives on the commission are from the legislature, from the legislative leaders. 4 legislative leaders, each of them gets an appointment as well. And the staff of the agency, led by the executive director, are all within the civil service. Really, really important. The executive director can't be fired unless for cause. So for me personally, I really try not to do anything bad to trigger that for cause provision. Otherwise, pretty much what I do in guiding, assisting the commission is all done without any review by any administration official. And the commission, I have to say, has a tradition and legacy of being apolitical. Now, I've been there 30 years, and I really have never seen a decision that involved politics. I'm really proud of that. Politics doesn't enter into the equation when reaching decisions. It just doesn't happen. Now, that's something I do think about because I'm not sure how you build that into legislation. You build in some protections, but people come with their own political backgrounds, right? And I just think it's a credit that none of our commissioners have ever exposed any political political motivations in any way. So that's one piece. We've been blessed, and we have wonderful commission members currently and for all time. So that's just one piece that I'm not sure how you ensure that, but we do have that. And then what we do, first of all, we issue informal guidance. We're there to just answer any questions that anybody might have, citizens, public officials, media. We really believe in that front end work. And we do training for public officials. We do all those kinds of things. We do mediation once we have complaints filed. It's a very significant part of our work. And the single most important piece would be our contested cases, complaints that are filed, adjudicating those complaints. We get up to 800 or 900 a year, formal complaints filed. So a case starts with a simple complaint alleging a violation of the act. There's no filing fee. There's no attorney required. And I would say most, maybe not most, but more than half, 2/3 perhaps, of complainants who appeal to us are not represented by counsel. So the expense of going through our process is minimized. Once a complaint is filed, our staff really works hard to mediate, ombuds our cases, or otherwise just arrive at a settlement short of hearing. And we do, I think as Toby mentioned, we do resolve more than half of our cases in that way. And one thing I want to say about our law in general too, and this was emphasized, I believe, in the article, that the burden is on the agency to establish the applicability of an exemption. There's no, there's no relaxed burden of proof. That's a principle that's cemented in our case law over many, many years. And if there's no resolution, the complaint moves to a hearing. The commission operates really like a mini courtroom. That's how I like to describe it. Both parties are required to appear. There's no opportunity out of it for the agency. You must appear. Both sides must appear and present their case. The agency must defend its actions, produce in camera if ordered to do so. And again, that I think is a key component, that we can review the records that are at issue in camera. And then parties must abide by the decision of the body. And the question about what if an agency doesn't comply, the FOI Act in Connecticut says that failure to comply is a Class C misdemeanor. Now that's not that big, right? But there is some potential for, criminal prosecution. And the FOIC hears non-compliance cases, that's what we call them. If a requester doesn't feel that the agency has complied, they can come back to us and ask us to review it again. The agency gets to come back and say what it did or didn't do. And we do have the option of imposing a fine. I will say we rarely do that, and the fines are small, up to $1,000 for a violation. So that's generally our process. And we do this for any person who wants to file a complaint, not limited to Connecticut residents, which some laws do limit in that way. And the media complaints are very small by percentage. I think most of our cases are from citizens interested in local issues that are personal to them. And after reviewing all that and hearing everything else that everyone had to say so far, these are the items that I think are critical to oversight. Independence, independence, independence. And it must be in the form of structure. No reporting to the administration, again, no running things by anyone, initiatives, legislative proposals, budgetary requests to someone in the administration, and no appeals within the agencies themselves. I don't think that that's a fruitful way to go about this, to have the agencies themselves that at an initial level deny access have a review process. Just seems like a generally unnecessary and wasteful step. And then when I talk about independence, I think it's critical that it includes budgetary independence built into the legislation in some manner, whether there's a pass-through budget that doesn't have to go through the administration, would go directly to, on the federal level, Congress. That's what we have in Connecticut, or a budget that has automatic increases built into it, because as we know, what the legislature giveth, the legislature can take away. And if you don't have the surety that your budget will in some way, shape, or form remain, then you're beholden to others to help you make sure that you get that budget. So you must have the resources both in budget, and I would also say in terms of staffing. We have 16 employees at our commission, which doesn't really seem like a lot, but I believe OGIS has less than that to deal with everything on the federal level, which is just wild to think about. And the agency must have flexibility, be able to resolve disputes formally like we have, but also have I think a complement of some other avenues to resolve matters, maybe incorporating some of the less formal processes to speed things up, because I think that is an outcome of our process. It does take a while. it takes a while to afford due process to everybody. So, you know, having a mediation system, having a summary resolution, maybe by agreement type process. And I think the agency, one thing that really hasn't been talked about, the agency, the oversight agency, must have the ability to ferret out complaints that really don't involve the jurisdiction of the agency or are abusive or otherwise problematic. And that's probably where I would add on to the Freedom of Information Commission here. Some of those elements we don't completely have fleshed out. So at this point, those are my thoughts. One last thing, some of the other countries that have, and there are many of them that have oversight bodies. A number of them approached the little Connecticut FOI Commission before forming those bodies. We were privileged to work with Mexico before it passed its Freedom of Information Act, some of the provinces in Canada, China, some South African countries. As emerging democracies were coming forward, we found we were getting more and more requests to explore our process. And I believe when some officials came from Mexico and we had them come and actually watch one of our hearings, I'll never forget the words that were said. This is like a science fiction movie, just watching that somebody can come into a forum like this, not worried about retribution, not worrying about the expense of it, and feeling like somebody's listening and actually having a role in deciding whether I will get access, and a body that is that has integrity and you know, the type of oversight that we have. So to them, it was like science fiction. They have since created, I believe, a better system than we have in Connecticut after a few jumps and starts. But I can talk about this forever, but I'll leave it at that. Thank you.
Thank you so much for that. I think the staffing levels that you mentioned are very telling. You know, 16 people does not strike me as an extravagantly over-resourced body. It's probably about the same as they have in Nova Scotia, where Toby's based, and that seems about right for a jurisdiction of this size. And to think that that's more than exists at the federal level is I think quite telling. So we've heard both about the political challenges that have potentially been raised. We've heard about comparative perspectives from Toby. We've heard Colleen's experiences in Connecticut. I want to give Margaret a chance to respond before we go to a broader Q&A. And in the meantime, I would encourage folks to who have questions to put them into the chat so that we can get to them and have a discussion based on that.
Thanks so much. And you've heard a lot from me, so I'll be very brief. But I'm inspired listening to Colleen and certainly share the concerns about the political viability of these next steps that Adam raised. And I think, you know, one thing that I'll maybe just add, and then I'll turn it back to the broader Q&A, is that I think that that we need to meet the challenge of the political reality head on. And one way it strikes me like that it is possible for us who are more on the academic side and law school clinics and folks to contribute to that effort is to try to make this kind of reform seem more typical, for to seem more normal, more comparable to other things that we already do in the United States. I think the comparative experience of looking at other jurisdictions is compelling in terms of why we need the reform. But if the hurdle is how can we do it, or is this really feasible for us, I think we also need to look internally in terms of what sort of comparable structures we have in the United States. And I actually think, and certainly at the state level, so I think, listening to Colleen, I see a lot of potential there to sort of harness that experience, but also at the federal level, we have sort of a variety of structures we've made to do sort of like as us law professors like to call it, non-Article 3 adjudication, right? So judicial review adjudication, and sometimes that's an agency structure, sometimes that's an independent agency structure, sometimes that's sort of like what we call a legislative or Article 1 court. And I think I know that there are folks that are working on this question about sort of doing comparable analysis, and I think that I think that that's an important piece of this that we can contribute in our more academic discussions to the effort to say, look, we've done, we've made structures like this before, we've made institutions like this before. It's not unheard of, and so I think building that case involves some of that, and not just the sort of obviously compelling need for better remedies at stake. So I will, and I do believe that case can be made, right? I think that we have enough flexibility and enough experience trying to design adjudication in the United States to draw on those experiences. So that's sort of the last thing I'll add. I know you've been hearing a lot from me, so I'll kick it back and just let our audience or however Michael wants to proceed in terms of the discussion.
Yeah, we've been getting some interesting questions into the Q&A, so I do want to maybe move over to there first, and then we can shuffle back to the questions that I have if we run out of steam there.
Michael, can I jump in?
Yeah, please.
The organizer's privilege and ask the first question, because there's one thing I was wondering if the panel has given some thought to. I'm thinking about the practicalities of doing something big like creating a new body in the US context and the partisan nature that we have to deal with in Washington, and Adam maybe could respond to this best, but the notion of doing something like using Connecticut as a model and setting up a multi-member commission seems really fraught in our environment. I mean, to comply with, congressional or constitutional concerns, if you have a multi-member body and they have to be approved by the Senate, you end up having vacancies that can't be filled. We have, agencies like FERC, Federal Energy Regulatory Commission, the Federal Election Commission. There's many examples, NLRB, that go for years without quorums and can do nothing. So that becomes kind of just another layer of delay. And if you say, well, the alternative would be to make one person, because then, then you run the risk that it becomes more politicized because it's going to change with every administration. But at least you might be able to, through the Vacancies Act or something, have a system where there's always someone in charge and it doesn't grind to a halt. I just wonder if you've thought about the practicalities, because it does seem like we don't have a good model that can work outside of the political system. And with the political system we have now, we got to figure out how this would function, and who's going to have the authority to do it. I suppose the other model would be to say, do it like the bankruptcy issue and create a specialized judge or a magistrate, a non-Article 3 judge that's not picked by Congress, it's picked by the judges, and have a FOIA judge in various places whose only job is to decide FOIA issues with then reviewed by the district court or something. But I just wondered if you thought through the mechanics at all, yeah. Or the feasibility. Would you be worried about a system where it was run by a single commissioner that was answerable to the president, and would that create as many problems as we have now, or not?
Yeah. Why don't we go to Adam first on the political terms, or on the political question that you raised, and then maybe we can go back to Toby and to Margaret on the more practical, or some of those more practical challenges of what to do about the existing structure.
Yeah, I mean, it's a great question, and I think there is some tension here. Maybe not tension is the right word, but an interesting dynamic, which is that a lot of the features that we've been talking about in terms of what would we need for a successful oversight body, the more robust they become, the more and more what you're describing actually sounds a lot like a court. And I think, what our Article 3 courts are supposed to be in the FOIA context. They're supposed to have complete, budgetary independence. They have this robust nomination, approval process. They have lifetime tenure. All of these things are essentially, we're describing what courts have. And so I think there should be room maybe, and I want to incorporate a question from the chat here too, which is, what is the role of attorneys in this process? I think there are a lot of questions presented in the FOIA context where you don't need an attorney, where you could have a smaller entity resolving disputes, like just getting a response to your request delay. Right, this is a common complaint of requesters. I think it's true, as the comment from Dave McCraw earlier, almost all FOIA requests that I litigate these days are just to get a response. And that seems like a kind of silly use in some ways of a full Article 3 court just to get the agency to do the first thing in the process. And maybe you could have a smaller independent agency to handle those types of things. And I don't think you even need a lawyer necessarily for that. But there are then very complex issues in FOIA where I do think oftentimes you do need an attorney. I mean, FOIA is more than 50 years old at this point. There are, I believe, in excess of 16,000 federal FOIA opinions. And some of these questions are very complex. Even what seems like a basic question, what is a record subject to FOIA, is a hugely complex issue. You have a Supreme Court case that says, well, there are 2 prongs in this test to decide what it is. And then in the DC Circuit, they've said, well, the second prong has 4 prongs to it. And each of these has to be adjudicated on a case-by-case basis. And those are really complex. And then it turns out that there are at least 2 alternative tests to this 6-prong test, depending upon where you are, that the DC Circuit might apply. And those types of really detailed legal questions, I think, don't lend themselves to a fully independent body with all of these powers, but with no attorneys present. I think that would be a really, really difficult task for a lot of average citizens or even journalists to engage in. So I think that the courts do need to be involved at some point. I think in terms of setting up, this a more robust independent agency, absolutely, but it may not answer all of the questions that we have. So Dave, maybe this is a very roundabout way of answering your question by saying, I'm not sure that we can fully replace courts, and maybe the courts need to be there as a backup. For example, if something is going wrong and this more robust third-party agency that we're thinking about, or third-party entity. But anyway, I'll leave it there and see if Toby has thoughts.
Yeah, why don't we go to Toby and then to Margaret.
Sure, thanks. Well, just to bounce off Adam's comment about what is information in the 4-part, 6-part, multi-part test, that's fascinating. I mean, if your legislation is written in a user-friendly way, that's a very simple question. Is the thing recorded? So this meeting is being recorded. It's recorded. If it weren't being recorded, it wouldn't. I mean, is it in a form that's recorded? Does it contain information? And is it held by the agency? Those are 3 fairly simple questions that really need to be asked around that. I mean, I'm not suggesting that there aren't necessary legal complexities to FOIA legislation, including, for example, the exceptions, which obviously are difficult. I think that what's important is to keep the administrative oversight system as far as possible away from the all singing, all dancing, incredibly legally and procedurally complex court processes, because the whole purpose of having it is that it doesn't do and look like that. If you're going to have that, just let the courts deal with it. There's no need to create another body. The whole purpose of this is that it is accessible to requesters and it is, processes things reasonably rapidly. Of course, as Colleen mentioned, I mean, you do need to respect the due process rights of participants and things like that, but otherwise keep it fairly simple. In Canada, certainly, and in many other countries around the world, it's absolutely not necessary to have an attorney. I don't know what the percentage of cases that are represented by attorneys, but my guess would be that it's certainly far less than 50%, but perhaps much less than that than in Connecticut. David, I mean, if you look around the world, and this is definitely a gross generalization, but what you tend to find is that more developed democracies tend to opt for a single person in the position, and obviously Connecticut is not suggesting that Connecticut is not a developed democracy, but it's an outlier, I think, in terms of having quite a large commission. Developing countries often opt for a multi-member body, and that is to some extent to protect the members from political pressure and of various sorts, which can flow in less legitimate ways in developing democracies. So Canada, Britain, the UK, Scotland as a separate one, every Canadian province, single individual in the post. But Mexico has a 7-person body, Sri Lanka has a 5-person body, so on and so forth. I think one person is probably sufficient for the US. And you mentioned sort of if this person reports to the president, but the whole idea of independence is that this body should not report to the president. It should be independent. Now, the exact ways to protect that independence in the US economic, legal and political environment would need to be sorted out, but reporting to the president would not represent that. Reporting generally to the legislature is the way to go with that. So I think that's really, really important. This idea that it would report to the president and therefore you need more members to protect the independence. There should be other ways that the independence is protected than through a number of members. So just a few thoughts.
And Margaret, we've heard some structural questions. I know that that's an area that you've been thinking about as well. Do you want to respond?
Yeah, absolutely. So one of the things I wanted to pick up on that Adam mentioned is, the question of sort of the evolution of legal interpretation of FOIA rights. It's absolutely true that it's now a complex area of the law, right? This is not, I certainly agree with that. So I'm not, I think we're still thinking through what this exactly looks like. So I'm not sort of espousing a definitive position on this at this moment, but I think some of the things we could think of or that could be advantages of having a specialized body is that those adjudicators would have such a specialty that in fact they would know this area of the law in a way that wouldn't require legal advocates to educate the judges the way we do for generalist judges, right? So in some ways it would, not that they're taking an advocacy position, but that they would, already start with such a high level of knowledge about the legal framework that they're applying that litigants wouldn't need the kinds of kind of legal help that lawyers typically provide in this area to go through that process. So I think that's one way of thinking about specialization, is that in some ways it allows us to replace some of the burden on the litigants to know the law with the individuals knowing the law. And we don't, typically in the US legal system, we rely on the adversarial process to educate judges, right? Because we don't assume their knowledge of all areas of the law, but that's not true for a specialized body. We really can, I think, have some shortcuts there. The other way to think about it that I actually think is sort of an interesting question about what we would want to happen. But it's also true that if this were created as sort of an administrative body, so an independent agency, that agency all of a sudden and its expertise delegated to doing this adjudication would probably receive Chevron deference from the courts in terms of its legal interpretations, right? So unlike right now, when no agency gets deference on its interpretation of FOIA, which is good, we might have a commission with the kind of expertise and mission-based, transparency forcing mission, right? To maximize transparency. That commission's interpretations, we may prefer those to what's happening in the courts in many ways, right? And we've seen this happen in other areas where Chevron deference operates to allow agencies to set an agenda based on those agencies' missions, right? And to interpret the law consistent with its statutory mandate. And those interpretations get some amount of protection. Now, whether Chevron deference survives the next decade or not, I'm not going to take a position on, but I think, there are some structural reasons to believe that we might improve the direction of legal interpretation under FOIA, and that I think the complexity issues wouldn't be necessarily a barrier to litigants or requesters going through a dispute resolution process per se.
Michael, can I just jump in very quickly with a couple of quick points?
Yes, of course.
Thanks. Yeah, I mean, I think that's absolutely right, Margaret, that the expertise of the body sort of mitigates the need for expertise among the applicants. And that starts already at the mediation phase of the process. The applicant just, all they know is that they're not satisfied. So they go there and then the kind of the oversight body takes it in hand, sort of runs it through. And if the applicant is away out to lunch and they misunderstand the process, and then they'll sort that out in the mediation phase and say, sorry, the agency didn't respond properly to you, and if it's the agency. And I would also note, and I mean, Colleen may have a different view on this, but what I understand is that quite a large percentage of these applications involve fairly obvious resolutions, often because the agency simply did not comply with the law. About 50% of the cases in Canada are of a procedural nature, so not involving exceptions, not involving a substantive question about exceptions, and the vast majority of those are fairly straightforward. I mean, sometimes they involve, line drawing, like, so was a timeline extension too long or not? But not, not legally very complex. And even the application of exceptions, because very often agencies claim exceptions, which simply, on a fairly well-established body of law that's around interpreting exceptions, is just not proper. So, and then I think it's obviously important for there to be an appeal from the agency's decision, from the oversight body's decision to the courts, whether the requester or the agency. And for more complex issues, the courts can go through the longer, more in-depth consideration that happens before them, and then they will set standards which will then be incorporated into the common law of the oversight body and become part of the system. So there's as with all of our legal interpretation systems, there's sort of a hierarchy of decision making, and that ultimately very difficult questions get resolved higher up the food chain, as it were, and then get incorporated lower down.
You mentioned Colleen. I did want to go back to Colleen, as one of the questions in the chat is, would you say the FOI Commission is an effective tool for getting the public information quickly? I think that you sort of answered that in your initial remarks, but I wonder if you could speak briefly to if you see a structural role for your office to play in promoting stronger implementation among government agencies. Do you find that there may be a systemic impact to support stronger and more robust compliance with the law by government agencies, just by virtue of the fact that your commission exists?
Yes, before I get to that, just if I can comment on the previous discussion in terms of whether the issues are, more about process, and there aren't a lot of them are not that complicated. I'm just going to say for our part, yes and no. Like a lot of the easy issues have been resolved. We have this whole body of law to deal with all of that, but I find particularly over the past decade with electronic information and the creation of new kinds of agencies that do government work, trying to figure out whether we have jurisdiction over those entities, and just the complicated world that we live in, there are many complicated questions that have not been addressed. And I find what happens, you know, we resolve all the easy ones. We have a lot of complicated ones. And then about 12 to 15 of our cases get appealed per year to the courts, which is a piece I left out. And whereas on the federal level, you would say probably deference is bad and you want that de novo review. As I think, you know, Margaret indicated, we have that deference when our appeals go up to the Superior Court. They're just acting like a reviewing court of the record before the commission. And the other piece is that our commission itself becomes a party, and our lawyers within the commission, again, not anybody from the Attorney General's office or from the otherwise from the administration, we defend our decisions in court. So another, you know, another layer, but that is often where the more complicated sort of new age issues get resolved in court, with, in theory at least, that deference given to the commission. Not always the case. Courts are supposed to give deference as long as our legal findings are time tested and reasonable, and judges have found a way to find that they're not time tested and reasonable, and in effect do a de novo review. But anyhow, I think the commission is effective. Again, it's sort of a yes and a no answer in getting people quick access. I think it's maybe not so much about the commission, it's about the strong law that we have that gets people decent access. And then in terms of the commission, the fact that people have a place to go to just bounce things off of us, and public officials very often just don't know. And they too will contact the commission and try to figure out what the law is. And there's a lot of room for quick responses and quick access, and even before a complaint is filed. And then I do think we have a role. I think the commission has a role in advocacy and advocating for reform, given our strong position in what we do in Connecticut and throughout the world. Our commission has been very supportive of me and our staff going before the legislature, reviewing legislation, speaking up on issues where we believe that it'll, detract from the current law that we have, explaining to legislators why they shouldn't do something, why the law already covers something. Occasionally we're criticized for that, for kind of being out there in terms of legislation and speaking in such a forthright manner. But I believe it's critical to what we do. It's all part of fighting the good fight, and again, making sure that what we have remains intact and isn't cut away.
Thank you. There's a question in the chat. The first question that we got actually in the Q&A touched on a proposal that I think I've heard a couple of times regarding fee shifting as an alternative to developing an independent oversight mechanism. The question is, there's two parts to the question. First of all, they're asking, has that provision been proposed and shot down in Congress before, which I am not familiar with, and maybe Adam or Margaret could answer that. But then there's a broader question about whether or not it would be effective. It strikes me that the government has some deep pockets to deal with these kinds of things if it comes up. So I think I'm a bit naturally skeptical, but would be very interested to hear from our panelists, starting with Adam, as that is a proposal that seems to come up whenever we have these conversations.
Oh, wow. I think we need a whole nother day of the conference to talk about this. So the way that the federal FOIA works right now is there is discretionary fee shifting if a requester essentially substantially prevails in some way. Again, not to get too much into it, but the requester basically has to show first that they substantially prevailed. That makes them eligible for fees. And then they have to satisfy, you guessed it, a 4-part test to determine whether they are entitled to fees. And that looks at various things, including the reasonableness of the agency's withholding, whether the records will benefit the public at large or only the private interest of the requester, all different kinds of things. I will say that it is, under the current regime, it is not impossible, but it is not easy to get an award of fees. And even when you do, it's often the case that you're going to get a haircut from the court in some way or another. If you look at different FOI regimes in the United States, there are some that have mandatory fee shifting, which is if you prevail, you get fees. That's the end of it. And there are even some jurisdictions that have even more powerful incentives. So Washington State, in addition to mandatory fee shifting, the court can also impose up to an $100 fee per record per day that it was improperly withheld. And guess what? I really like doing public records requests in Washington State because you get very quick responses. It's wonderful. And I see Dave Collier, Professor Collier is in the chat here. He's done some interesting research showing that in states with mandatory fee shifting, you tend to have better compliance on average with the FOI laws. So all of this is to say, it's a very interesting philosophical question. Do you kind of try to build a good structure from the ground up, or do you impose very harsh penalties at the end of the process and have a kind of almost Darwinian evolutionary situation where the agency tries to figure it out? Ooh, I really don't want that penalty. Let's make things work in the back end. I think a lot of that depends also on how the penalty is structured, right? So whether it comes out of the United States General Fund or whether it comes out of the agency's own fund. I think a potentially dangerous situation is where it comes out of the FOIA or FOI budget itself, right? You don't probably want that because then that's going to have a dangerous knock-on effect for FOI compliance generally. But if the agency feels the pain, I think there's some empirical evidence to show that it does lead to better results. In terms of congressional reform, just very quickly, it has been discussed. I think certainly after the Buchanan decision from the Supreme Court came out in, I think, 2004, there were discussions about whether FOIA's fee shifting regime survived that. And as part of the 2007 amendments, Congress did shore up the fee shifting provision. So it's not impossible. But I think there would be reluctance to make it a very strong regime, in part because, as Professor Quokka has told us and studied, so many FOIA litigants are pursuing purely private interests and not those that I think FOIA was really designed to promote.
So Toby or Margaret, did you want to address the fee shifting question?
I'll just quickly jump in to say I couldn't agree more with everything Adam just laid out perfectly. I think there is some promise there, but I don't see that as the sort of the one big shot that's going to really change the dynamic a lot. It is true though that having a simpler, more, a kind of a mandated fees, right? To have a mandatory fee shifting provision would simplify the process greatly. I mean, at this point, the government is, for example, I as part of my research, a request that I did for FOIA logs, I ended up having to litigate. Public Citizen litigated it for me because I didn't have time at the time to do it, and then they won, and then they were denied fees. On the basis that I had a commercial interest because it was for my academic book. And so, which I don't know if anyone knows anything about publishing an academic book, but like, you know, if your royalties off that get you a dinner, you're lucky. So and then they had to appeal it to the DC Circuit, and then they eventually won in the DC Circuit. But I mean, this took years, right? Years of them fighting this collateral fight to get fees for, you know, my clearly non-commercial interests. And so I think, you know, it is clear that we need, I think, reforms in that area. I just don't know that that's going to be enough to change the dynamic enough that we don't also need to be thinking about other structures and other remedies for requesters.
Jump in very quickly on that. I mean, I think I don't know a lot about fee shifting, but for that to be successful, it would have to engender structural changes, profound structural changes in the system, so that the vast majority of requesters that never go to court, and therefore won't have fees shifted to them, you know, will benefit as well. And I'm very, very skeptical that that alone would do that. That said, I do think it's important to look at, you know, apart, separate from the question of appeals or recourse upon denial or whatever, the whole incentives system. And Adam, that's an interesting mention you gave about the $100 a day. In India, they have a very, very effective system. The Information commissioners can themselves impose, it's only 100 rupees a day, but scaled down to the Indian standard of living, it could be somewhat similar. And that is imposed directly on individuals who are mucking around and not behaving properly within the system. And that is credited by many Indian advocates with being the single driver that makes their RTI law work. So I think, you know, I mean, different incentives in different places, but I do think a whole, you know, much more sophisticated package of incentives, including, as I said before, compensation for delays, that sort of thing. I mean, somehow to, you know, to push back on delays, because you can't fix the delay with an order upon appeal because it's already too late. So I think that, you know, the whole issue of incentives needs to be looked at quite carefully. And there's a lot of possibilities there, basically.
Colleen, I don't know if you want to jump in on the question of the sort of toolkit and these potential options that are there.
Yeah, the issue of mandatory fees has come up in our state many times. And I guess I agree with everyone else. I think it might be an interesting tool, but it's definitely a complicated one. That, you know, the whole notion of, you know, whether you substantially prevailed or not, that can be complicated. But I do think the incentive issue is really interesting. And in our state, and I really hadn't thought that much about it in this way before, but in our state, the penalties that we can impose, again, just $1,000 for a violation, is against the individual. So we individually name the officials. We require the party to identify who they think the official directly responsible for the violation is. And, you know, I think that's the idea, that potentially that person is on the hook for that fine. But there's no process by which we monitor that. And I think probably from a practical standpoint, the agency ultimately would pay that on the person's behalf. So, you know, I don't know how you even really monitor that, but I think that is why that's there, to kind of incentivize the individuals. And then I just worry about fees in general, that it's, you know, just the cost of doing business type thing, and that if they are paid out of the agency line item or just the agency budget in general, you know, that money would be much better spent in looking at ways to reform the structure and the process, as opposed to, you know, having the agencies pay fees. They may just decide, well, that's again a cost of doing business in this area.
So we just have, we're just about at time, but I wanted to just quickly, if we have a moment, go back and maybe just touch on this issue of mutual support networks that potentially exist among independent oversight bodies, because I know we have certainly some folks from OGIS in the chat, hopefully some folks elsewhere that are connected to other information commissions. Maybe Colleen or first Colleen and then Toby, could you just very briefly touch on some of these mutual support networks that exist among different oversight bodies to help one another in common challenges that are faced?
Well, I think the organizations to which our agency belongs and I personally belong are certainly helpful in providing that mutual support. I've been part of an organization called COGL, which is the Council on Governmental Ethics Laws, and it's largely ethics and campaign officials, oversight officials, but there's a nice small open records, open meetings component to that group, and their support and just bouncing ideas off of each other is a wonderful resource, and also makes you feel like you're not alone when you feel very alone on these issues. In our state too, we have the Connecticut Council on Freedom of Information, which is an organization that was originally comprised of media folks who were behind passage of the Freedom of Information Act, and they do some lobbying on behalf of open government issues, and we work collaboratively with them, which is wonderful. And then we have our Connecticut Foundation for Open Government that works on First Amendment and open government issues. And those three things really help. And I think the voices in Connecticut, they add to the voices in Connecticut that help keep government officials on track and make them wary of doing things that would negatively impact our law.
Toby, do any such networks exist at the international level?
A loaded question. Yeah, so the internationally, there's what they call the International Conference of Information Commissioners, ICIC. Don't know if Connecticut's a member, but several of the Canadian provincial and the federal ones are. It has just really gotten formalized as an organization over the last few years. The current chair is the chair of the Mexican oversight body, and so they are exploring and tooling up very much in terms of providing support to new bodies and obviously a forum for exchange of ideas and discussions and things. I'll also mention quickly that in Canada there are couple of quite influential, large networks of individuals who work in this area, information and privacy officers, or within agencies or within private bodies, because they also have private privacy people, and they do a lot of awareness raising and training, and also publications and all kinds of support through them as well.
Thank you so much. So we are just a couple of minutes over, so I will cut it off there. But I want to thank all of our panelists for their fantastic contributions. It's a great and a diverse group of perspectives to hear on this important issue. And I think there's a lot of food for thought for folks that are contemplating how to improve the freedom of information system.
Yeah, thank you so much to all the panels and to Michael for being our moderator. This was a really fascinating discussion. So thank you again. And everyone, we're going to take a quick break. We'll be back at 11:15 for our next panel about the rights of the press clause. Thanks again.